Good morning, everyone. So please take your seats, start communicating with your colleagues, and prepare for a very productive day. So for our second day of our conference, my name is Irina Slavinska. I work at a public broadcaster, culture radio, and I'm also in the board of JurFem, and it's very pleasant for me to be with you here. And as we promised yesterday, we finished the day by working together. We had a brainstorming session to collect your ideas of solutions of different issues we discussed. And now Kateryna Shunevych is ready to present what you worked on. So these are not ideas that came out of nowhere. These are all your thoughts that you collected during the hour yesterday. So Kateryna, I'm giving the floor to you. Thank you. Good morning, everyone. Please take your seats and look at the screens. We have a small presentation based on your ideas. So I would like to remind you that we work with 3 issues. So children, witnesses, and victims. So their status. So that was the first issue. Then sufficient evidence for GBV. And the third issue, how to do pre-trial procedures and not to re-traumatize victims and witnesses. So let's look into the first issue, and that's where we had the most proposals and ideas. So all groups worked on the list of challenges that we have in our state and solutions. We tried to unite all the clusters, so let's look into this about the challenges. So the first problem that you highlighted, that's it's impossible to become automatically a victim, like officially to get the status. If the person is underage. So there has to be some action of the legal representative of the child to get the status. Then the second problem, that there is a refusal to open the case, and so the child or the person cannot become officially a victim because the case is not open. And that's, of course, the whole other discussion of whether it's possible to refuse to report the case. And then the absence of confidentiality, because usually parents or the community, they have concerns, and so they don't want to report to the police. And they don't want to get engaged into the whole procedure, especially if we talk about small communities, so how to do it all confidentially. Then problems also about legal representation in criminal proceeding and the mechanism of change in the legal representative if a mother or father are not fulfilling their parental duties, or if they are potential suspect in this criminal proceeding. And among the issues that you noted, that if legal representative does not act in the interest of the child, or if there is no legal representative at all. For example, if one of the legal representatives became the victim and died as the result of this crime. Then also the status of underage person, if a legal representative can be a possible suspect in the case. And here we can see a situation when legal representative does not report the case in the interest of the victim, or the interest of the underage person does not align with the interest of the legal representative. For example, if the legal representative wants to hide that this crime was committed at all, or there are some cases if the legal representative, one of the legal representatives is a potential suspect and another legal representative is a potential victim. Also, sometimes legal representatives refuse to continue to participate in criminal proceeding as a result of reconciliation, according to Article 46. So also some issues that were mentioned. There was pressure from the police, so they are pressured not to report. So basically we are discussing some negative practices in response. And then police officers don't mention children in the case of GBV, and in this way children are not getting the status of victims. Not enough collected materials for the child to get the official status of the victim. And so here probably we need to discuss, when the case is reported, that probably we need to add additional information that underage person was harmed. Then there were two cases of what to do if violence was committed on the internet towards the child, and it's very difficult to identify this violation or crime and how police should respond. And another issue that groups discussed, that's identifying victims according to Article 301 of the Criminal Code of Ukraine. These are the cases so these are activity about around pornography. If we talk about recommendations, recommendations were in three areas: legislation, practice, and training about legislation. One is amendments to the Criminal Code of Ukraine, 54-55 articles, and to have provision that underage person can automatically have an official status of victim in these criminal proceedings. Another proposal was that there should there should be a change that the case can be open not if information is received from any source, not only the report of the victim. And then there was a proposal of amendments to clarify definition of child witness, child victim. Another aspect, these important amendments, 477 article to update legislation about 152-53, which is about rape and sexual violence, 126, domestic violence. So these cases need to be open if the information was provided by any source, not only the report of a victim. And another proposal, so the obligatory legal representative of underage person, the same, so to have the defender, the same way as we have legal representation for suspect. Another section of recommendations, it was recommended to have some changes about not reporting domestic violence and to have it as a separate norm. Amendments to Criminal Code of Ukraine not to make it impossible to force reconciliation or settlement if it is GBV, and also amendment to legislation of a safe isolation of a child from an offender. So I know that reconciliation, that's something that is being actively discussed, but the main proposal that only the victim and the legal representation can initiate this, and the court needs to check whether it was truly their initiative and not pressure. Also, then to update some norms about psychologists working with children without parents' consent. Probably it is quite controversial, but that was your proposal. So then recommendations. We try to prove with your pictures that you worked on these aspects. We have the following recommendations: to exclude factors which so basically it has to be obligatory that the child was present and becomes the victim of domestic violence, and so it has to be added in the protocol when the information is collected. And probably here you talked about as administrative offense, but we need to see this recommendation. Then the active position of social services for protecting children, then changes about legal representation. So it is necessary to change legal representation if it is necessary, and this should not be changes to legislation, but procedure and norms to understand who this person can be. And of course, it has to be obligatory to take the report, to file the report. So, and to have a multidisciplinary approach on pre-trial phase. So we already discussed that legal representation and to provide the free legal assistance. So it has to be obligatory to provide a lawyer to an underage person, and also to describe procedure of how to find this lawyer. And also there was a recommendation about specialization for prosecutors and investigative judges. Also to have a special position in national police who can 24/7 communicate with their child victim without consent of parents, and collect information to prevent domestic violence. Also trainings for the national police, especially in the section of child victim, child witness. Also, it is very important to have educational and awareness campaign for everyone, kindergarten, schools, colleges and universities, on the level of community, local authorities, not only the police, in order to develop approaches and understanding of the members of the community what GBV is. Also, multidisciplinary trainings. So the training should not be just the police, but different professionals should be at these trainings. For example, police together with prosecution to understand the approach of every institution and to develop an algorithm how to act together, to increase the number of green rooms, the number of investigators, to improve the work of cyber police, social advertising. So this is, and this again all around the child victim, child witness of GBV. The next issue that the groups worked, that was sufficient evidence to prove GBV and take into account the needs of the victim. So the challenges that you presented, that's where we started, how to collect evidence if a lot of time had passed since violence was committed. Another, that's prejudice of investigator, but I believe it's not only investigator. I think it's overall the prejudice of the community and also prejudice of professionals, which can potentially influence how evidence is collected. Then the issue with witnesses, so usually witnesses are lacking or absent completely, and witness has no right to personally engage experts, which means that the witness the victim doesn't have as much rights as the suspect. Also, the interview is not done on time or not fully, which means that the interviews will be done again, and which means that it can lead to re-traumatizing. Here also you discussed that so when the person drops charges or when the person doesn't want to participate in a procedural process, then stigmatization. No psychologist working full-time, so it's impossible to have the analysis by a psychologist or psychiatrist. And another issue, and lack of confidentiality, we see that it appears again here as in the first issue. So if people who work with these topics, you see this issue everywhere. Recommendations, among recommendations, these are so to make engaging of psychologists obligatory to all victims, not only underage persons. And we know that according to our code, it is suggested only for underage victim. But if it's GBV, so it's quite sensitive, so psychologist needs to be engaged every time, and it will prevent re-traumatizing the victim, and it will allow us to collect high-quality evidence. Also, to extend using the Article of 225, and to organize interview according to according to this article. Also about the amendments to Article 225 about interview that has to be done immediately. Some groups suggested that it has to be about 10 days after the report. But of course it is quite problematic, because if it's not done, then it will be a problem with bringing the perpetrator to justice.
Another duty is to notify the victims to keep their material evidence and necessary action that need to be done within 72 hours. And then the updating of laws the indirect evidence or evidence obtained from other persons. Another 225, the expedite the collection of evidence, psychological assessment, collecting court experience, applying electronic evidence, video, audio, and 24/7 access to forensic expertise. And the last problem is risk of repeated traumatization of the victims. So these recommendations partially were duplicated compared to other. Second question, the admissibility and of the evidence should be done also to avoid the traumatization of victims. Problems. There were many repeated interrogations, total and repeated re-traumatization, reference to the same events, no special rooms, the technical facilities not enough to have green room. Just yesterday we were talking how to actually do this interview. Even if you have a green room, does it still maintain the best private interest of the victim? Not enough psychological assistance and support for the survivors and victims. That's also a challenge that they've been talking about. The problem of green rooms in Barnahus, that was the topic of yesterday's discussion. As we were saying, traumatization during interrogation, pre-trial investigation, whether the results of the interrogation could be used as the Article 225, because the judges, when they interpret the evidence, they don't always account for the results of such interrogation or interview. Recommendation, so to apply and to expand the list of subjects under Article 225, so a possibility of additional interrogation during the court hearing, interrogation for green room, not only for underage but for persons at all, and anyone who wants this kind of as a service, creating a staff psychologist unit, possibility of interrogation by the same-sex person, as was example, to allow the person to choose which gender or sex investigator they would like. So that was a proposal, maybe. Then a qualified psychologist when the initial interrogation of the victim, court psychological assessment, video without attendance of the victim. I know that there is experience in that, but then there's the question of exhaustibility of the evidence and how admissible it is. The one-stop shop mechanisms, we talk about coordination and reference and redirection, designing algorithm and instructions, what do you do with the victims of gender-based violence, and the determining of the terms of litigation deadline, which is also open for discussion, but we have the proposal here. And also to finalize, there was a proposal to have re-interrogation with video recording to avoid repeated interrogation, and allocating necessary time for interrogation to get as much valid information for certain criminal proceedings to proceed. So that's not exhaustive, but some recommendations, and I hope that as a result of this event, they will be the foundation of the new amendments to the law. Thank you.